As the Education Coordinator for OHA Headquarters, I would like to welcome you to today's webcast, Trending Discussions in Employment Screening. OHA is pleased to add to our 2017 webcast programming with this informative and educational event. Before we begin, I would like to remind the audience that all attendees are on mute and to feel free to submit questions throughout the event via question box on your webinar toolbar. We will reserve time at the end of today's presentations for questions. Following the event, you will be allowed to evaluate today's sessions through the webinar tool. Your feedback is greatly appreciated. This presentation will also be available to download on the OHA website. And with that, I would like to hand it over to Wally. The floors are yours.
Thanks, Amy. I appreciate it. Like she said, we're going to be talking a little bit about some trending discussions in employment screening. I have an outline here that we'll go through really quick. But before I do that, wanted to just do a little bit of house cleaning items at first and let you know that I am not an attorney. I don't play one on TV. But I am going to be discussing some things that, you know, there's a lot of litigious things around what we talk about and what employers implement. So just want to let you know that you can check with your own employment law attorney or your attorney if you decide to implement any of the ideas or things that I suggest in here. And you just need to look at your own policies and procedures and the law with respect to how that fits into your company. So just want to get that out of the way. The next thing I kind of wanted to just give you guys an idea of what we're going to be talking about today for the agenda. It is trending discussions on employment screening. The agenda is going to last about 1 hour, and obviously this is a webinar format. We're going to be talking the first 8 minutes. I'll spend some time talking about you know, what are some of the most important checks an employer can conduct, and depending on the employer and what they do, what are those things that are important. Then maybe some of the things that we found are why post-hire screening is on the rise. Talk a little bit about that. That'll be about 8 minutes. And then we'll discuss if employers are permitted to screen employees for prescription drugs and some of the things with that, some of the cautions and the issues with that on the drug screening side of things. We'll talk a little bit about the common flaws in employer drug testing programs and spend about 7 minutes talking about that. Then we'll jump ship and talk about some I-9 compliance, some of the mistakes that are made there. And that's about 7 minutes, and then we'll follow up with the risks of using some social media to screen candidates and talk a little about the pros and cons of doing that as an employer. And that should leave us about 15 minutes for questions at the end, and I'd be happy to answer questions. You can type those in, and if we don't get to all the questions, feel free to still submit those questions. I can get a hold of you after the presentation and can answer the questions for you. So with that being said, we'll just jump right into the presentation here. The first trending topic that we're going to kind of look at is why it's important to verify a job candidate's past work experiences and also their educational accomplishments. This screen actually isn't probably the most important screen for every employer. They're usually looking at criminal records or, you know, some other type of record, but there are some compelling reasons to consider adding this to the screening mix, and I just want to show some information here that will support that. So with background checks, there's, you know, a myriad of things that you can do. A background check, a lot of times people think a background check is just criminal, but anything where you're looking into the background of a person, you know, is gonna require a different check. So whether they have a professional license, you know, you're checking previous employers. Even on the criminal side, it's broken down into so many different areas. There's your county check, there's a county criminal, there's a statewide check, there's a federal check. A lot of people get confused with the federal check meaning a national check, which that isn't the same. There's federal courts, there's state courts, there's municipal courts. So there's all different kinds of criminal checks. There's fingerprinting, which happens through the FBI. So a myriad of different kind of checks that are all done in different places, and none of these different sources speak to one another. So there's a lot of different areas to go to find information. And I just wanted to bring that up because it is an important point with that. There are also outsourced social media checks, which we're going to talk about, where you can hire a company to do the social media checks for you, where they have screen scrapers that pull information and all of that. So we will talk about that a little bit, but just so you know, there's a ton of different checks. When you talk about background check, background check really implies a lot of different things. Speaking about the verifications that I talked about earlier, if an applicant wants to pad their resume, it's really a calculated risk for them, because most employers are just screening through these resumes, looking at them quickly. Some of them have software to pull from keywords. Excuse me. Keyword searches that pull, the resumes together to alert them of the good candidates. So it's kind of a calculated risk for them. But according to the latest benchmarking reports, 45% of all resumes contain at least one major fabrication. And 70% of employers spend less than 5 minutes reviewing those. And that last one there, 42% of small businesses don't even verify previous employment. So that calculated risk for the applicant becomes much more tainted towards them if these things are happening here. The employers aren't reviewing the resumes. So that's something to look at. Something here too, I wanted to just provide you, these are kind of comical in some ways. Here are some of the creative embellishments that we've received from our company. We've uncovered these over the years. One of our customers, he claimed to be a Nobel Prize winner, and he was not. So we actually verified that, and he wasn't. Another claimed to be a former CEO of the company, which he was actually applying for. So just a totally made up thing, and actually went and applied for there and said he used to be the CEO of that company. So one claimed to have worked in an area, and it was actually in a jail where they were really serving time. Someone claimed to be employed at 3 different companies in 3 different cities simultaneously, and believe me, these are real people that are putting these on resumes, so it's kind of crazy. We've had many that have had attended colleges that don't even exist, and with all of the diploma mills out there and things like that, they put as much work into making up a fake university and fake diplomas, giving them to people, as they would if they started a legitimate business. They even verify them. So there's a lot of those out there, diploma mills. Finally, one guy claimed to be HVAC certified, and then once he was hired, he asked the hiring manager what HVAC meant, HVAC. Didn't even know what it meant. So those are the types of things that are happening. People are trying to get jobs, and so they're embellishing their resumes. So I think it's important to kind of look at that kind of stuff. Again, just kind of beware. We're finding that employers need to be digging a bit deeper to find the wolf in sheep's clothing. This doesn't happen a lot, but those exceptions sometimes are the ones that are going to bite you. So you just want to make sure that you have a good, solid screening program in place. Another thing, if we look into a candidate's past work history, many times it can reveal insight into their job stability and possible loyalty to the employer, so that you can gauge whether they're going to be loyal to you. And it's important to note that employers have to actually obtain permission from a candidate before conducting any check, including when they do any verifications on a previous employer. And it's also possible for candidates to deny that position to an employer, but you can ask for additional information like a pay stub, a W-2, or other tax document that actually prove that they were employed previously. But again, they can actually deny you permission to go and check with the previous employer, and you cannot check with them if they deny that. So that's something to keep in mind. The next thing is, you got to consider what the nature of the job is. That kind of determines the most important reason of what you would want to search on the background. This is pretty obvious, but I just wanted to throw it up there. If you're going to hire somebody that's driving around, you're going to do an MVR check. If you're hiring someone that is in a very sensitive position, you're going to want to do a deeper check and make sure that you're finding people that are not going to cause damage or hurt your other employees. So a healthy mix of screening tools kind of works best. So that's just a brief introduction on screening, and some of the important things that I think I would add to a screening program is the verifications. And the next thing that I want to talk about, moving on into the next area, is why post-hire screening is on the rise. And post-hire screening is screening once you've already employed this person. Let's make sure that they stay clean and that they aren't doing things once they've been hired. So, why is it on the rise? Why are companies doing it? Well, to address this plain and simply, insider threats are growing. And we've seen in the news the exposure of government secrets, Edward Snowden, the 2013 Navy Yard shootings, which was quite recent, DC situations that we just had this last week, holiday party in San Bernardino. All of these things are increasing, and I know this sounds like throwing things out there to be a scare, but they're happening and they're on the rise, and it's actually working, and a lot of employers are starting to implement these because they all have increased the focus on post-hire insider threats. Insider threats range from embezzlement, fraud, theft, to child molesters and active shooters. These come from anyone with access to the workplace, including employees, contractors, temporary employers, and even sometimes ex-spouses. So just because an employee met your job requirements at the time of hire doesn't mean that nothing has happened since then and that they could potentially be of concern. So a lot of times companies are doing screening after they've hired them, and I'll talk a little bit about some statistics with respect to drug screening on the post-hire side of this later on in the drug screening part of it that shows a compelling reason to do some screening there as well. So that being said, I wanted to give you some information here. I only have up through 2015, but we're seeing that 2017 or 16 is trending about the same rate. So it's about 36%. So it is on the rise, and companies are doing more post-hire screening. So this source was taken from a report from 2013 to 15, but recent reports are showing that it's still trending upwards. So just wanted to point that out. So the question comes up, why rescreen? In some industries, for instance, transportation and health care, ongoing screening is a compulsory thing. So they're actually compelled to do the screening. Now, we aren't in agreement with companies or industries being forced to do anything, but we know a lot of times government regulations mandate that things happen with the drug testing, for instance. So beyond the industries that are compelled to rescreen, we do continue to see companies that are rescreening employees to help maintain safe and secure environment, to protect their brand possibly, and ensure that their employees are moving into new positions or qualified. So anytime there's a promotion or something like that, they will do that post-hire screening. And again, I think it's important that companies are doing it to protect their brand beyond the companies that are mandated to do it. So I think that's interesting connection there, that even though they're not mandated to do the screening, they are looking at that. So what's important to know here about this topic? Really, post-hire due diligence can identify something that could have been missed in the initial screening or the post-hire screen or the pre-hire screening section. It can also reveal new threats that could arise. Sometimes people, go to work and then something happens while they're working there. A change in circumstance. Maybe they go through a divorce and a really bad divorce, and it causes some issues. So with so many organizations whose employees have access to sensitive personal information or physical access to facilities, they're starting to see the importance to review and reinforce their policies around the rescreening, and so that's been kind of one of the things that they're looking at is post-hire screening. So moving on to one of the other topics here, the topic of prescription drugs. This has always been a hot topic, but recently it's starting to happen. There's some talk around DOT allowing for more than a 5-panel test, although I don't know that's going to happen very soon, but there's always talk about it. There's talk about removing some of those because of the marijuana becoming so popular in medical marijuana and things like that, and we'll talk a little bit about that. But with the rise in awareness around prescription drug addiction, this makes it's pretty high up on that hot topic list. So let's talk a little bit about this issue and what employees are legally permitted to do. And again, if you have any questions about these things, go ahead and submit them, and we'll take those at the end. From our experience, many employers are concerned with the impact of prescription drugs, especially in the workplace, because it can cause, impairment. It can cause sleepiness. If they're driving, it becomes a safety issue. So clearly the use and abuse of prescription medications can have a negative effect on the workplace. Some of the specifics are the increasing potential for on-the-job accidents, and negative impact on the job performance, and providing a stronger impetus for workplace theft. Not only because maybe they need to feed their habit, so they're trying to get more money, so theft becomes an issue, and in some cases, safety issues can arise even if the medication is being used legally and is directed by a physician. So those are all points to think about when you're looking at implementing a drug testing program, whether you do just the 5-panel illicit drugs that are illegal, or whether you open it up to a panel, whether to include highly addictive or highly abused prescription drugs. So some statistics out of the news. I'm going to kind of point out some of these, but employers are finding out quickly that the use of these medications is a serious issue that deserves their attention. In the 2011 survey by the National Institute on Drug Abuse, the NIDA, nearly 20% of Americans older than age 12, reported using prescription drugs in a non-medical manner at some point in their lifetime. I think that's interesting, all the way down to the age of 12. NIDA also reports that prescription drugs are, after marijuana and alcohol, the most commonly abused substance in the U.S. And recently, the Centers for Disease Control and Prevention have classified this type of abuse as an epidemic and indicate that the fastest growing drug problem in the U.S., with 1 death every 19 minutes. which is crazy. So this being said, there is some evidence that prescription drug use and abuse is growing problem in the workplace. And then on that last one with Quest Diagnostics, there's been a marked spike in the incident of employee testing positive for prescription opiates, more than 40% from 2005 to 2009. So that number is increasing. However, unlike illicit drugs, for which most of the U.S. employers can easily test for, and legally prescription medications present a number of challenges to organizations. For one, the mere presence of the substances in a drug test does not constitute offense. So you may do a drug test on this person, and even though it's in there, it doesn't constitute an offense, and you might want to be using a medical review officer to look at those to make sure there's a legitimate reason for that drug to be in their system. So that's something that you need to think about as well. There's also laws and regulations. It's important to keep those in mind, and especially the employees that are using prescription medications. They're protected by the ADA. You as an employer can't just go in and ask them what drugs they're using, what prescriptions they're on. It can cause issues for disability lawsuits. For instance, if you ask them for their prescription medication, even when you're doing a drug test on them, if the employers ask for that information and the employee discloses that information to their employer, they now have information that could cause them to discriminate. Maybe they're taking a medication that's commonly used for AIDS, and so they discriminate against this employee because of the medication they're taking. So there really are issues with that you want to be careful about. You don't ever want to ask them. You want to make the third-party collection facility ask for that information and review it only with an MRO. Those things can be quite compromising to employees. So workers do have the right under the Act to claim privacy with respect to their health information, and they don't have to share the details of medication use with their employers. So that's something to really keep in mind. Here's a situation that can possibly help provide some guidance to employers as they look at this issue. In 2007, an automotive parts manufacturer was concerned about, they thought there were a higher rate than normal of workplace accidents at one of their factories. And so the employer suspected that the underlying cause of that was that they had some drug problems. There was drug use by employees. So the company actually banned the use of several prescription medications. So they came out with a policy and just said that they're banning the use of this. And then they actually did a drug test on everybody that comprised of a 12-panel drug test instead of the 5. So they opened it up to all of these other drugs that are commonly abused, with the opiates and the other things, specifically the ones that they banned as well. And then they found that there were a lot of people that had abused prescription medications, or they found that there were a lot of positive hits on these. And then they actually went a step further and took adverse action, including suspension and termination against several of the employees who tested positive for these substances. And a lot of those had legitimate prescriptions for the medication. So even though they felt that, that contributed to the lot of accidents that were happening in their plant, they just took it upon themselves to go out there and say you can't do this, and then do a drug test and then terminate them. Well, of course, the U.S. Equal Opportunity Commission, the EOC, heard about this and subsequently initiated a lawsuit against the company. And they did this on the basis that the drug testing violated the employees' rights under the ADA, which is what we just talked about, the Americans with Disability Act. And the case actually resulted in a $750,000 award in favor of the EEOC, which contended that the employer's actions constituted unlawful medical inquiries and required medical examinations that were not job related or consistent with business needs. That's directly from the suit. So you got to be really careful about when you're handling these things, how you handle those, and it would be probably wise to involve a medical review officer in situations like that. So what are the recommendations? What do we need to know about this? Wrapping up hot topic number 3. So just up top there, the EEOC recommends specific set of conditions that you can require with workers for prescription drugs. Potential exceptions to that, employees in safety-sensitive positions or in a post-accident situation. Those are exceptions to that rule. They have some latitude to inquire into or even test for prescription medications if used by the employee. Of course, organizations that are regulated by the DOT or any of the other active areas, the FMSCA, all those different areas pursuant to 49 CFR Part 382, which is the DOT rules. Any drivers, things like that. Although there is things in place in the law to make sure that safety-sensitive positions, even if they are on prescription drugs, there are things in place with DOT to kind of handle that too. But employers should be very careful in these situations and have their legal counsel to help guide them as to when this type of inquiry or testing would be appropriate, especially with those DOT, because that is a very sensitive area. And then again, as I've been saying all along, consider using an MRO. An MRO is mandated in DOT testing, but for private companies who aren't under the mandate of DOT rules, they do not have to use an MRO, but an MRO is a medical review officer that has been trained in pharmacology and knows how certain drug medications interact with each other, and also how long they stay in your system and things like that. And they can tell whether the drug test result was caused by a medical condition or medical treatment, or if it's being abused. So that's something very important to look at as well. So moving along to hot topic number 4, just a statistic here, about 65% of mid to large size companies currently conduct pre-employment drug testing. And with rapidly changing marijuana regulations being adopted across the country, these employers, these 65%, are taking another look at their drug screening programs in 2017. So while employers are taking steps towards creating safer and more productive workplace, many have made common screening missteps in the development and management of their drug testing programs. And that's kind of what leads us to this hot topic here, the common flaws in employer drug testing programs. I'm going to go through a few of those. So what's important to know, especially about your drug testing program? An inadequate drug testing program could fail to detect individuals who abuse illegal drugs or other illegal substances. And these individuals can actually pose an increased risk of causing workplace accident, which could result in costly litigation, the reputation of your company, damage with your company, PR issues, any number of things. And for organizations that actually have state and federal contracts, employing those individuals that abuse substances could pose compliance risks, any number of things with that. So to help minimize these risks, employers should evaluate, I would say there's 4 things that you should really focus on in your drug testing program. I'm going to go over those. The first one is random drug testing. It can be an effective tool at detecting drug abuse in the workplace, but that being said, there are several risks that employers may face if their drug testing program isn't developed and implemented properly. Just an example, an ineffective random drug testing program could allow individuals to avoid detection. If you're not doing a truly random program, it's easy for them to avoid detection. Do the amount of notice given also the individual? I know we've had situations where you tell them that they need to go in for a random test and give them a couple days to do that. But even a couple of hours sometimes, or if you send them without someone, a lot of times if you send them off-site for a drug test, they can stop by a buddy's house, fill up a clean bag of urine with their buddy, you know, in a condom or a balloon or something and tape it to the inside of their leg, which happens often, so that they can get the temperature at the right temperature and then use a substituted urine, someone else's urine for that. So those are kind of risks that happen. Again, on the other side of it, well, in that case, by limiting the time between the notice and testing, you can actually help reduce the likelihood of them being able to substitute anything or be able to avoid detection. So the other risk down there that they should consider is how they're actually selected. Is it a truly random program? What is your selection program? You know, if you pull someone out of the hat, so to speak, are they put back in there for the next selection process, or because they've been tested, do you keep them out of it? That's not truly a random program. How are you looking at the random and how are they selected? It also mitigates the risk of discrimination claims. So those are important things to consider in your drug testing program. The other thing I would look at is the compliance issues. Clearly understand the drug testing regulations in your state. Each state is different. And then if you have federal contracts and you're managing drug testing of federal contractors, that's another thing that you need to look at. So when you look at all these, the varying laws by state, the federal regulations that come into play, even with non-regulated employees, a drug testing program can become quite complex. And it's critical that employers understand the myriad of laws and regulations that impact their specific drug testing program, or you can face compliance risks. And if you aren't regulated by any laws, if you have a company policy that's in place, that becomes your law. So if you're out of compliance with your policy, that could become potentially an issue as well. So employers actually should understand the drug screening regulations in each state which they operate specifically, and organizations that operate under a federal contract may be even subject to stricter requirements, including the need to ensure a drug-free workplace with the Drug-Free Workplace Act of 1988. So beyond the DOT rules, the FAA, FMCSA, which is the Federal Motor Carrier, you know, there are other agencies. I'm not sure if anyone on the phone is on this call is associated with those, but Federal Transit Authority, the Pipeline and Hazardous Materials Safety Administration, United States Coast Guard, all the organizations that fall under the Department of Health and Human Services, they all need to understand the alcohol and drug testing requirements that they must adhere to. And those situations, there are some pretty severe fines for incompliance with those rules and regulations. So that's another important one to keep in mind. Another statistic, and point number 3 here that I would look at, is about 65% of mid to large companies conduct pre-employment screening only. 39% of those have implemented a random drug testing program. So the problem becomes, you know, we know that this company only does pre-employment drug testing, so we're going to clean up for a pre-employment drug test, pass the test, get on, and then start using drugs again, which happens, you know, with some of those drugs, heroin, can be out of your system in 2 to 8 hours. Some of the other ones, meth and opiates, can be out of your system in 2 to 3 days. Cocaine, 2 to 3 days. Marijuana lasts a little bit longer. If they're a heavy user of it, it can be in their system for up to 30 days, 3 weeks to 30 days. So, really all they have to do is stop using the drug for a month or so, apply for the job, they're clean, then they can go back in and start using the drugs again. So that's why it's important to have a drug testing program that includes random. So once you do the pre-hire, you can make sure that you have a workforce that's providing safety. Another risk is the uneven implementation of drug testing across the contingent workforce. There's only about 22% of companies that are drug testing employees who are also testing their contingent workers. So if you have any contractors or anything like that, and those compliance issues and liability issues still can come on you with contingent workers. So that's something to look at. You need to check with your attorney if that's applicable, but there are some things that can happen there. So for employers with a large contingent workforce, this oversight could cause some substantial risks. You want to be careful about that. And then number 4, something I said we were going to be talking about. This graphic is an old representation, but I just wanted to throw it up there. I think when this graphic was done, there were 22 states, plus the District of Columbia that allowed some form of medical marijuana. Now there's actually 29 states that allow for some sort of marijuana medical use. And then there's actually 12 more states that have pending legislation right now. And beyond that, there's 16 states with laws that specifically about the CBD, which is the cannabinoid, I can't say that, cannabinol. So this conflict between state and federal laws puts employers in a tough position. That's something you have to look at. So the Federal Controlled Substances Act still classifies marijuana as an illegal Schedule Drug 1, illegal Schedule 1 drug. So according to the federal law, that hasn't changed, but state laws are conflicting with that. That's something that you want to look at and make sure that there's no conflicts in there. In addition, on the same note, employers should consider outlining a specific policy to address medical marijuana in their actual policy. It doesn't really matter what you elect to adopt as far as tolerance goes. You can have a zero tolerance. I've seen that a lot, where people just say we have a zero tolerance drug-free workplace policy, excluding even card-carrying medical marijuana users, which some employers do that, and that's possible, and you can do that. But employers that don't have a federal or industry regulations and are operating in states that allow the medical marijuana usage may want to consider creating a tailored policy that allows for medical marijuana usage for some of the low-risk jobs that don't make a difference if they're answering phones, or something like that. But it actually bans the substance for high-risk positions. So you can actually dictate by position the specific drugs in the policy as long as it's specifically listed out. So that's what some people are doing, and some of the trends that are happening with some of the companies that want to give some low tolerance to those people who do have card-carrying medical marijuana access. Moving along now to hot topic number 5. What are the most common I-9 mistakes? If you look at the first page of the I-9 form, it comes with enough rules and regulations to fill a 69-page how-to manual. So the government really is good at coming up with ways to make us jump through hoops and look under rocks and in between, they make us jump through a lot of hoops to be compliant, and that's very frustrating for a lot of employers, especially small employers that don't have a lot of time and effort to devote to these types of things. So it's really no wonder why it makes the list of most common hot topics. Also, there's a lot of debate and a lot of political rhetoric going around right now about immigration and things like that. So that comes into play and brings it even more of a hot topic. And no matter what side of the political spectrum you're on, there are certain rules that are law, whether it's enforceable and being enforced, depending on the administration that's in the White House, really depends on the administration of those things. So not only on the side of the enforcement of the people who are out of compliance or are here illegally, but also enforcement to the companies that are employing individuals that are here illegally. So that's one of the reasons this kind of makes the hot topic list, and I guess enough said about that, we can go on. But there's a myriad of common mistakes that we've seen, and there's human error, and then there's also errors that are done by documentation, by actual documentation not right. The documentation that you receive from the applicant is not right, or it's falsified. So a lot of those errors cause problems for employees. So if an employer fails to complete or maintain the I-9 documentation correctly, that employer could fall out of compliance with Immigration and Customs Enforcement, which is ICE. And those rules, if not kept, they can suffer harsh penalties, and those are financial penalties that come with violations. So just for your information, fines for I-9 errors begin at $110 per error, and they climb to tens of thousands of dollars per error for repeat and grave offenses. So if an employer has one form per employee and multiple mistakes on each form, the financial penalties can quickly escalate into even 6 and 7 figures. There was a well-known clothing retailer who recently reached a settlement with ICE regarding I-9s. It was discovered that during a 2008 audit, the company paid, this was settled a couple of years ago, but the audit was back in 2008. They're going to pay more than $1 million in fines, and they have to cooperate with the federal authorities and modify their electronic I-9 management system. So they had to go through a bunch of steps to complete it. So in addition to the fines, it caused them a lot of work, extra time to do the audit. The company incurred additional expenses, including legal costs, and added time for its employees to actually respond to the audit and go through that process. So that's something that you want to keep in mind. I know these are larger companies they typically go after, but with this administration, there is a high likelihood of more enforcement on these types of things. Typically, we've been seeing that on the immigrants mostly, but there are also some enforcement going on with employers as well. So this is kind of a tough slide, but I've listed six potentially high cost reasons for and common mistakes that are made, and these are the ones I want to keep in mind. I'll discuss each one of them a little bit, but on the first one, incorrect or missing forms. Common I-9 documentation mistakes, they include, but they aren't limited to this type of stuff. Incorrect dates, missing signatures, transposed information where they've put their name on there wrongly, or have their maiden name on there and they're registered with the with the Social Security Administration or DHHS as another name. So it's also, possible for the employer to fail to complete the I-9 form altogether or misplace it, the completed form during filing, and maybe it got put in the shredder or something. So that's under incorrect or missing forms. Another challenging aspect of this is employers recording the document codes for each of the identification methods. So all the codes are similar to a routing number on a personal check, and they appear as strings of embedded numbers in different locations on different forms of identification. So if an employer asks for too many identifying documents from list A or B or C, that could expose you to an employer to discrimination allegations. Asking for too few documents could result in an incomplete form or a violation there. So that's another thing with missing or incorrect forms. Number 2, out of compliance with the 3-day rule. A lot of you know about this, but ICE rules stipulate that the I-9 form must be completed within 3 business days of the employee's first day of work. So this means that the employee must complete section 1 of the form, provide identification documents, and have those documents verified by the employer all within 3 business days. Sometimes, as you know, new employees, they'll forget to bring the documentation. You give them some leeway, 3 days passes, and you're out of compliance with that. So with companies with a lot of locations, it can sometimes be challenging to get all the forms and documents complete and verified and then send them onto a separate corporate location. And if that employee fails to meet the 3-day deadline, it could result in hefty fines for the employer. So that's something to look at as well. The third one there is failure to re-verify. For employees of certain citizenship statuses, those who have right to work status or a visa or a green card or something where they have a separate status to work in the United States, they all need to be tracked and updated to the employee supporting I-9 documentation file. For example, at the time of hire, a work authorized alien will provide documentations where they show their eligibility to work in the United States, but then that expires at a certain time. So you have to actually look at that and keep track of when that supporting documentation expires, keep track of the expiration dates and all that. And when you have a lot of workers like that, it's extremely difficult and time-consuming to manually track the expiration dates for all of these things because they expire all at different times. And you need to remind the workers to provide the updated documents, so they have to go get them, and then once they get them, they have to show them to you. So even with the complicated spreadsheets and filing systems, there's still room for human error on the employer and employee side. Employees can easily slip through the cracks and unverified, and the company can be out of compliance pretty easily. Moving on to number 4, invalid identifying documents. In the flutter of activity during hire, it can become difficult for hiring managers to check that all the necessary documents are presented and valid. So if an employer fails to obtain the right combination of identifying documents from either the list A or the B or the C, then the I-9 documentation would be considered incomplete, and the employer becomes subject to the fines. And that is one of the most common mistakes for hiring managers, to request too many or too few documents, which can result in discrimination suits, like I said before, on the I-9 violations respectively. Many forms of identification on the list also have expiration dates. And if an employer fails to obtain current identification that they have, that can also put them out of compliance. Improper documentation maintenance on 5. ICE rules require employers to maintain the I-9 forms either 1 year after the date of termination or 3 years after the date of hire. So whichever is greater. So purging outdated forms is is a good way to free up storage, but it also can help you on compliance, because one of the problems that happens that if you're audited by an ICE agency and they come in and they find you that you haven't destroyed or shredded things that are beyond that time, you may be subject to fines for that, but also they can actually look through those, and if you misdocumented things on those ones that are out of the time range, they can actually fine you for that as well. So you get kind of a double whammy. So that's kind of an important thing to look at as well, is make sure that you purge those things either 1 year, let's see, 1 year after, 3 years after their hire date, or 1 year after I lost my train of thought there. 1 year after their date of termination, or 3 years after the date of hire. And then this last one here, lack of supporting documentation for E-Verify photo matching. If you remember, those of you that are doing this, back in 2010, E-Verify introduced a photo matching as a way to prevent employees from using the false identifying documents, because they found that HR people, they aren't document experts and don't know if someone is giving them a false document or not, so they implemented this. So for passports, passport cards, permanent resident cards, and employee authorization cards, the E-Verify system will actually require employees to compare the document photo with an on-screen photo as an additional security measure. ICE mandates that employers maintain a copy of the employee's photo identification as supporting the I-9 document. Since E-Verify photo matching is a new measure, it's likely that a majority of affected employers are not aware of the additional requirement to keep a copy of the photo identification on file. So if you fail to maintain that copy or identification, you could be in subjection to a fine, and you need to have that supporting documentation. You'd be in violation. So simplifying the I-9 compliance, really, how do you do that? Bottom line is, if you want to avoid fines, there's one way to avoid at least human error, and that's to employ an I-9, electronic I-9 solution. That's really one of the best ways to do that. So if you have a solution that is integrated with your background screening, an electronic I-9 solution is probably one of the best things to do there. Looks like I've got about 10 minutes left here. Where the last topic that we're going to talk about, I'm just going to quickly bruise over, is social media files. They've become popular, and employers are looking at social media files to screen their employees. So why is using social media to screen candidates still risky? Let's talk just about a few of those things, and then we can wrap up with some questions if we have some time. Quickly, 84% of employers use social media. This was from a human resource management study done. 43% use social media searches online to search candidates, and 1 in 3 employees disqualify applicants based on information they found on social media. So why is that scary? Well, we'll talk about some of these things. It's just the numbers certainly put job seekers on notice, because it helps them keep their social media profiles clean and their applications true. But it also opens up employers to the risk that they'll learn details about the applicant, such as race, age, religion, disability, pregnancy, any of those number of things that open you up for liability. And those things are protected and legally cannot be taken into account in making hiring decisions. So once you've seen something, you can't unsee it. And so that's really the risk. Even though you may think that you have an objective mind, you've seen something, you've seen a picture about them that automatically puts you at risk and could possibly taint your idea of who that person is. So it's important to keep in mind that there are nearly 20 states that actually bar employers from requesting access to employees' social media posts. So actually employees or applicants. So even if they're an applicant, that's what the law specifies. But the employer is within their right to view what is publicly available. So you can actually go out and look at it. But just because you can view it doesn't mean that you can use it. Just for an example, the University of Kentucky paid $125,000 several years ago to settle a religious discrimination case after a university professor claimed that he was passed over for a job because of the views he expressed about evolution on his website. So he had a separate website. And there are justifiable reasons to weed people out based on their social media activities. One example could be you can disqualify someone that was found to be posting racist jokes. Profiles that don't align with an applicant's resume can raise red flags about anything that they're asking about. There's also positive reasons to explore the profiles, such as confirming the applicants are creative, good communicators, they're well-rounded in their personal life, things like that. But it's kind of a balance. You need to look at the risk versus reward of using social media. With all this ambiguity, there is some guidance. And again, this is my last slide. So there is some ambiguity on this. You can consider separating the recruiting from hiring policies, encourage settings, and also encourage employees to use good judgment. Those are kind of some things. But if there are any questions, I don't think we have any time for questions. We're about at the hour mark. I apologize for that. I went a little bit over. But if you have questions, feel free to submit those. I see that there are a couple on there, but I'll get back to you with answers to those questions, and we can go ahead there. For the final slide, if you are getting certification credit, SHRM code is right here, 17-8X7LL. That will give you 1 hour credit towards your SHRM. And then if you want your HCRI credit, this presentation is qualified for both of those. You can do both or either one. This HCRI code is 306652. That also is credit awarded for a 1 hour certification on the HCRI. Again, if you don't get these codes or haven't written them down, feel free to reach me and I can email these codes to you. Also, if you weren't able to view the whole presentation, which you probably aren't on here now, if you dropped off, you can come back and review the rest of it later and get those codes and receive credit. Thank you very much for your time. I appreciate your time, and I will turn the time back over to Amy if she's there.
Perfect. Thank you so much, Wally. Again, thank you, each of you, for participating in this webcast. A special thank to our speakers today for providing this learning opportunity for all of us. As a reminder, a recording from today's webcast will be available to download on the OHUG website. And Wally, thank you so much for sharing your contact information. Feel free to reach out to Wally directly if you have any additional questions. Have a lovely day, everybody. Take care.
Thank you.